Bonjour à toutes et à tous. Je m'appelle Vanessa McDonnell. My name is Vanessa McDonnell, and I'm co-director of the Ottawa Public Law Center. Bienvenue. On va parler aujourd'hui de l'affaire récente de la Cour suprême du Canada dans la ville de Toronto, City of Toronto. We're going to get started in just a moment here. I wanted to let you know that this event has simultaneous translation. And so at the bottom of your Zoom screen, you will see an interpretation button, which you can press to access simultaneous translation. Nous avons la traduction simultanée aujourd'hui. Alors, il faut juste appuyer le bouton en bas de votre écran Zoom. Si vous ne voyez pas le bouton, c'est sans doute parce que vous n'avez pas la version la plus récente de Zoom. So if you're not seeing the interpretation button, that may mean you don't have the most recent version of Zoom and that you need to update your Zoom platform to access the interpretation today. I'm speaking to you today from the traditional unceded territory of the Algonquin people, and we pay respect to the Algonquin people who remain traditional guardians of this land. I'm very pleased today to moderate this discussion with a diverse group of scholars who have all been thinking about the significance of the recent City of Toronto case and who are going to be sharing their first impressions with us today. And I think it's important to emphasize that, you know, it's a case that has many dimensions, lots of big issues. And so I think we're all still at the stage where we're trying to assess its significance. So this is in many ways a first conversation and not the last conversation. Alors, je vais commencer juste en faisant des introductions très brefs. Je commence avec Alexandra Flynn, qui est professeure adjointe à la Peter Allard School of Law de l'Université de la Colombie-Britannique. Ses principaux champs de recherche portent notamment sur le droit municipal, la gouvernance et le droit administratif. Mike Powell est professeur agrégé à la faculté de droit de l'Université d'Ottawa et membre du comité exécutif du Centre de droit public. Sa recherche porte sur le droit de la démocratie, le droit constitutionnel comparé et le droit électoral. Steve Chaplin est un fellow au Centre de droit public, ancien conseiller parlementaire pour la Chambre des communes. Il se spécialise en droit administratif, en droit constitutionnel et en matière de privilèges parlementaires. Puis, on a Marie-France Fortin, qui est professeure adjointe à la faculté de droit de l'Université d'Ottawa et membre aussi de notre comité d'exécutif du Centre de droit public. Elle s'intéresse notamment au droit constitutionnel comparé et au droit administratif et plus précisément ses articles et présentations portent sur la prérogative, la couronne et l'immunité de celle-ci. Shoshana Weedle was supposed to join us today, but unfortunately is not able to. So we've reshuffled her questions among the group, and we'll look forward to hearing her views on this case from a comparative perspective some other time. So we will dive right into this discussion, and I'm going to start off with a little summary of the case. Many of you will be familiar with it already, but I thought it might be useful to, for me to set just provide a bit of a summary of the case. So as many of you will know, this case has been working its way through the court since 2018. When newly elected Premier Doug Ford's government introduced legislation reducing the size of Toronto City Council from 47 to 25 members during an ongoing municipal election. And so that legislation passed quickly and was then challenged in court. And before the applications judge, Justice Bello Baba, there were a number of constitutional issues raised. And so there, the argument sort of narrowed a little bit by the time that the case reached the Supreme Court. But at trial, the argument was that this legislation violated freedom of expression, freedom of association, the charter right to equality, as well as the unwritten principles of the rule of law and democracy. Justice Bello-Baba concluded that the legislation infringed freedom of expression and that infringement could not be saved under Section 1. The province was then successful in obtaining a stay pending appeal, and importantly, that meant that the election did go ahead on the basis of the reduced number of ridings. When the case was heard on the merits at the Ontario Court of Appeal, the court sat as 5 justices. A majority of 3 judges allowed the appeal and concluded that the province had acted within the scope of its lawful authority in changing the number of wards during the election. And in doing so, they called this essentially a political matter. And so the court concluded that neither freedom of expression nor any other provision of the charter was infringed by the legislation. The majority of the Court of Appeal also rejected the arguments that had been advanced on the basis of unwritten constitutional principles. There were 2 justices who dissented at the Court of Appeal, and they essentially adopted the freedom of expression component of Justice Bello-Baba's decision. So they would have concluded that changing that number of ridings mid-election infringed freedom of expression unjustifiably. So we then get to the Supreme Court, and a majority of the court, led by Chief Justice Wagner and Justice Brown, dismissed the appeal. They too, like the majority of the Ontario Court of Appeal, concluded that the province had plenary authority over municipalities and that there was nothing about this legislation that they enacted that was that infringed the charter. Specifically, with respect to the freedom of expression claim, the majority concluded that the claim that had been advanced in this case was actually a positive rights claim, a right to a particular platform, and that triggered the application of the Bear test as opposed to the standard Irwin-Toy analysis for analyzing whether there had been a breach of freedom, a negative rights claim, a breach of freedom of expression. And so here the test was, of course, more stringent. So the claimants would be required to show that that the legislation substantially interfered, that the failure to provide access to a particular platform substantially interfered with freedom of expression. The majority concluded that on the basis of the evidence, there was no substantial interference. And so this meant that Section 2B was not triggered in the particular circumstances of the case, or that there was no violation of Section 2B in the circumstances. The majority also talked about unwritten constitutional principles, and in an important ruling concluded that unwritten principles are not capable of invalidating democratically enacted legislation. And so on that basis, the unwritten principle of democracy could not be invoked to invalidate the province's legislation. There was a strong dissent written by Justice Abella for 4 judges. And in that dissent, Justice Abella raised concerns about treating this particular case as a positive rights case. So in her view, what we were dealing with in this case was an infringement of freedom of expression. And that meant that the standard Irwin-Toy analysis should be applied as opposed to the Bear framework, which would have just looked more simply at whether the legislation in purpose or effect interfered with freedom of expression. Applying that test, she concluded that reducing the number of wards during the election did constitute an interference with freedom of expression, with the expression of both voters and candidates, and that that infringement could not be saved under Section 1. And in doing so, she concluded that the legislation did not have a pressing and substantial objective. Finally, she took issue with the majority's analysis of unwritten principles. In her view, the majority read down the existing case law in finding that unwritten principles could never invalidate democratically enacted legislation. She also concluded that that unwritten principles are not limited to the functions that the majority said that they were able to perform, and the majority had concluded that really principles fulfill a gap filling or interpretive function, but they could not go so far as to invalidate legislation. So that's a quick summary of the case. And as you can see, there are all sorts of legal and constitutional issues in there to discuss. And we're hoping to touch on as many of them as we can in the next hour or so. I'm going to get started with a series of questions now. Je vous invite, si vous voulez, de laisser des questions dans le portail pour questions-réponses. Vous pouvez poser vos questions maintenant et puis on va avoir une période de questions à la fin de notre conversation. All right, so I'd like to start with Alexandra. So the majority's decision contains a strong reaffirmation of the plenary nature of provincial jurisdiction over municipalities. So what I'd like to ask you is what you think this decision means for municipal law and governance.
Absolutely. As Vanessa and I mentioned earlier, this is like a dream come true for nerds who care about any of the issues that are covered in this case. I'm really delighted to be joining you from the traditional, ancestral, and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh peoples. And there's basically three ways in which I want to answer your question, Vanessa. The first of which is that even though the decision was deeply divided, as you noted, municipalities are very likely to be more cautious. And we've already seen more caution even in the few days, really just a month that the decision has been released. So if you look at the majority decision, it seems to be unequivocal that municipal governments have no independent constitutional status, and a province can take any action in relation to municipalities that it wishes. And this is because of a very strict reading of the Constitution of Section 92(8), as well as Section 3 of the Charter. But in fact, the decision was deeply divided, and not just at the Supreme Court of Canada, but also in the many stages that the issue had been heard along the way. So the Ontario Court of Appeal was itself very deeply divided. At the trial level, we saw Justice Balobaba decide in favor of candidates who were running for office, in effect against the province's decision. So this issue is far from over. This is not a subtle divide on the bench on three critical issues, including the nature of positive and negative rights, the use of unwritten constitutional principles, but also of municipal authority itself, whether looking at textual material is the only way in which we understand municipalities' powers. And this really matters. And it matters because in part of the way that the question was framed and the way the question was answered by the different justices. And as all of us here know, and probably many of the people listening, as we tell our students, the way that we frame the issue, the way that we frame the question will matter in terms of the answer that we get. And so here, the majority and the minority approached this issue in a different way. And that signals how alive and important this matter will be over time. The other kind of troubling issue from the perspective, just from a pure law perspective, is that this decision lays a lot of questions about judicial review. So this very court, these very justices in Vavilov just 2 years ago outlined that municipalities had a unique kind of role when it came to judicial review. Okay, I'm maybe exaggerating that a little bit, but they certainly stated that in looking at how municipalities are going to undertake judicial review, deference needs to be given, in particular in the area of reasons. So where we're left with is a really uncertain framework. Do municipalities get more latitude when it comes to whether their decisions are going to be reasonable, but no latitude at all when it comes to the province intervening if they don't like a decision that a municipality has made? And the reason this matters so much is that municipalities are going to struggle with what they can and can't do. So already we've seen cities deal with this conundrum. So in their review of inclusionary zoning in the city of Toronto just last week, several councillors sent back an amendment that would have just been a normal amendment that councillors could make to any decision, but they sent it to legal because they didn't know if they had the power to make this decision. And just to clarify, the city of Toronto is the sixth largest government in Canada, including provincially. Do we really want a big city like Toronto, or any city that's grappling with big decisions, walking on eggshells every time it wants to make an amendment to a decision that it has legal authority to make? So that's my first point, that municipalities are likely to be way more cautious and way more judicious, even though this issue is far from settled. The second point that I want to make is that this decision really does profoundly interfere with the critical democratic role that municipalities play. Municipalities have legitimacy as democratic bodies, and Mike will talk more about this, but decision after decision at the Supreme Court of Canada level has clarified that municipalities are on the front line of decision-making, that they represent their residents, and that they're essential democratic partners in Canadian federalism. And the proximity to local people within their communities is a key part of what role municipalities play. And this is exemplified by the ward boundary review itself, the decision itself that gave rise to the Premier's actions in overturning the electoral district. So on one hand, the City of Toronto engaged in a 4-year process with countless reports, hundreds of stakeholder interventions, trying to arrive at a decision that represented its residents in a way that also met the legal requirements. And with a stroke of the pen, we saw the province just overturn this process. So this completely undermines the critical role that municipalities play as democratic actors. And then finally, this decision does not actually address the real problems that face municipalities. This is like the bread and butter of what I'm passionate about, but what all of us are passionate about, which is that there are big problems within our country when it comes to the powers that cities are able to execute on behalf of residents, including the authority that they have under various statutes to raise revenue, the appropriate scale of decision-making for critical issues like homelessness, and clarity on municipal responsibilities in relation to Indigenous peoples. So this decision also leaves a troubling precedent for undermining these other questions which demand to be heard. Thank you.
Thank you. Yeah, I think you've identified a number of things there, but one of the interesting ones I think for me is this tension between the increasing recognition of cities as being important legal and constitutional actors, and then this sort of very small sort of dependent role they seem to occupy in the City of Toronto case. Mike, do you want to follow up on Alexandra's comments?
Yeah, gladly. Thanks very much for having me. I'm really looking forward to the discussion and happy to be here with everyone. There's a lot to say. I think one of the reasons the case is so fascinating is it brings together two things that are very underspecified in the Canadian Constitution. One is democracy, right? We don't know anything about how the electoral system works. You don't know anything about what the prime minister does if you read the text alone. Similarly for municipalities, if you just read 92.8, you have no idea that they are democratic, that they are representative, that for many people, it's the government closest to them that deals with issues closest to them. And then as Professor Flint said, Toronto is larger than multiple different provinces. And so you get no sense of that from simply reading the text. So this case brings those two things together in a very fascinating way. And so we had a line of cases that was trying to create some space and to recognize the fact that municipalities have this democratic role, that they are seen as legitimate, and that their size indicates that they're playing a different role than they did in 1867. The majority decision doesn't really engage with those cases. The minority does. And so that leaves us, as you said in the introduction, this is the beginning of a conversation. So it makes me wonder, are those cases artifacts of the McLaughlin Court, and they're no longer there, and municipalities are creatures of the provinces, and that's an on-off switch, and there is no spectrum of authority and responsibilities? Is this specific to the City of Toronto case, which attracted a lot of political attention and journalistic media attention, so that sometimes changes the dynamics? Or is this just going to be the prompt to more political discussions on how to amend the Constitution, or for provinces to draft statutes that give even more leeway to municipalities and reassure municipal voters that they are going to keep on having their democratic say? So how this fits into the underspecified nature of democracy in municipalities is very interesting to me. I just wanted two other quick points. I know we have a lot to get to. The majority doesn't think effective representation can be the standard under Section 2B, because that's a standard under Section 3, which applies to federal and provincial elections. And I know we'll talk about overlapping rights, but it should be pointed out that every day, municipalities who draw new ward boundaries, new electoral maps, are judged on the effective representation standard, because courts and administrative bodies in the different provinces that review them need to have some standard to determine whether the map is fair or not. And what they often do is to say Section 3 does not apply, we get that, but we're going to use the same standard anyway. So there's a gap between what's happening in terms of how maps are drafted and how they're reviewed and what the majority says on that point. Lastly, I would just say, and I said this at the time, the map that was imposed is, I think, itself unconstitutional. And so the map that Toronto now has is the provincial map, which is, with only a couple of exceptions, the federal map, because since the mid-90s, Ontario has largely copied the federal districts drawn by an independent federal boundary commission, with a couple of exceptions, especially in the north. But the Ontario map that now applies provincially, federally, and municipally in Toronto did not stick very closely to representation by population, even within the relatively wide variances that are permitted by the Supreme Court in their interpretation of Section 3. So there are serious questions whether the map itself on its own meets the standards that we have for other elections in which it's used. I'll leave it there.
Thanks, Mike. So I'm gonna just come back with a quick question for you, Mike, that I think for me is a larger question about this case, because what I see on the in this case is, a bare majority, a 5-4 majority for a fairly different interpretation of different parts of the Constitution. And so I guess the question I'd have for you, Mike, is, do you think much then depends on who replaces Justice Moldaver when he retires in a couple of years? In this kind of context where you have a bare majority for arguably sort of different visions of the Constitution, do the individual justices not become quite important?
Yeah, I mean, I'm probably not enough of a informed court watcher to have a really definitive view on that. I think one of the interesting things, the unwritten principles, which I know we're going to talk about, like the case could have been resolved without the unwritten principles being discussed, and right, in terms of whether you can invalidate legislation. So I get the sense, again, early impressions, the court this was on the court's mind for a long time. It was in academics' minds, obviously, for a long time, and lawyers. And so it provided the opportunity to delve into those issues around unwritten principles, but the issues were so specific, right? Mid-election interference, municipal elections. The lawyers in the case quite appropriately brought many different kinds of arguments. So basically every kind of argument you could imagine was there. So I'm more likely to view this as a unique case rather than something that projects into the future, maybe with the exception of positive rights, which I know we're going to talk about.
Yeah, great. Okay, I'm going to go to Steve now. Steve, in light of what some might see as a reaffirmation of legislative power in this case, what do you think this decision means for legislatures broadly, and then for their kind of, and for their power vis-a-vis the other institutions of state?
There's actually, before I answer the question, I just want to make one comment following on what Alexandra and Michael said, and that's the question of democracy and municipalities. And I think one of the things that the court did not look at the effect of the ongoing democratic relationship between citizens and their municipal governments. In other words, they focused very much on the election and the electoral process, but they did not look at the effect of the democratic principles of how people will engage with their cities. And I found this, and it leads to the point that I'm going to raise in a second, a quote from the Minister of Municipal Affairs in the legislature. And he basically says this: debates are time-consuming, inefficient, and costly. And that begins to tell you something about how the provincial government approached municipalities. I mean, they don't see them as necessarily democratic institutions, but they see them more as basically businesses. You got to be efficient. Democracy gets in the way of decision making, and I think that's really quite troubling in many levels. And that sort of leads me to answer your question. And I just think that's important for us to recognize. They don't look at the consequences of what the new municipal government does. They just focused only on the electoral issues. And I think that was, that's quite troubling. The second point, though, is this, and it flows from the point that I just made, is that one of the things that this government did was it used time allocation to pass the legislation. So it did not want to pay any attention to anything that came before, in the sense of all of the studies, all of the reviews, all of the kinds of comments that might have come up in legislative debates. So what happens is the court and the government tend to sort of hide behind the fact, oh, this was a legislature's decision, this is what a legislature did. But when you really look at it, the legislature didn't do much other than pass the legislation that was put before it, because the government uses time allocation and closure basically to shut down debate, not only in Toronto going forward, but also in the legislature when it passes the law itself. And there's a study that recently came out that says that even in the Ford government, they've used time allocation 70% of the legislation that they pass. And what that means is that the government basically is bypassing the legislative processes in all of this. And I think that this is going to cause some tension down the road in the courts, not just on the municipal law thing, but on a general principle of, right now, the courts are saying things like, well, the legislature considered it, reasonable limits, it's legislative. We're not going to interfere with what the legislatures do. We're not going to look at the legislative business. But when there's no business there, the question, I think, will ultimately come, at what point will the court say, as they did in the UK in the Miller case, which has nothing to do with this, but had to do with prorogation in the UK, where the courts basically said, whoa, I mean, if you're going to be bypassing Parliament or you're going to be bypassing legislature's government, you may be acting unconstitutionally. And I don't know how long it will be before that issue of time allocation and closure and those kinds of issues, because it was used here, is actually going to play out. I know the court doesn't look at that, but I think you can see in the provincial government's approach to democracy and just basically shutting it down municipally, shutting it down in the legislature. I'm concerned that eventually we may have to start examining, even how democratic decisions are made in the relationship to how far the courts can go or will go, in saying there really was no democratic debate. There was no democratic discourse in some of this decision making. How valid are they, or how much deference should the courts be giving to the fact that, well, these are, quote, democratic decisions, when the democratic institutions aren't given the opportunity to act. So I think that there are a lot of, not just in the particular case, but just the way the legislation came about, how quickly it was dealt with, is going to cause some other problems for democracy and democratic institutions down the road.
Those are really interesting comments, Steve. And this is certainly, something that I've been thinking about as well. And, the thing that strikes me when you look at the Miller 2 case and you compare it to City of Toronto is, in Miller 2, the court gets engaged, right? To the surprise of many, the court actually says we're going to enforce certain unwritten principles here. In City of Toronto, they do the opposite. And so the interesting thing now is post City of Toronto, courts have one less tool at their disposal to address the kinds of very real democratic concerns that you're identifying. And so, I do wonder where that leaves us. Alexandra, do you want to add anything here on what you think this means for the relationship between different orders of government and the courts?
Yeah, I agree. I think it is a troubling precedent. And it was wise of Steve to point out that the lack of recognition of the democratic role of municipalities was actually mirrored in the democratic process that the province used itself. So in that sense, there's a symmetry with how democracy itself is viewed by the government in the crafting of this decision. I do think that the couple of things to pull out. One is that there is a rich intergovernmental conversation that is very important, that forms the backdrop of the powers that different governments assert and the way in which they engage with one another on a day-to-day basis, that is really lost in the body of this decision. So, alongside something like the City of Toronto Act or most provincial legislation, there are intergovernmental tables where bureaucrats are hammering out agreements to the very urgent issues that face governments all the time. And I think from a democracy perspective, there's, what happens in legislatures and there's what happens in city council meetings, but there's also what's happening at those tables and in the relationships that exist amongst people who are working at different levels of government. And this decision really harms, I think, the backdrop of those relationships, which is pursuing democratic aims. It is to make decisions in the public interest. And the lack of judicial attention to that with the majority decision, the lack of recognition of the importance of democracy as an unwritten constitutional principle, I think calls into question just a whole range of decisions, not just those that make their way to decision-making forums, but also those that exist on a day-to-day basis with different actors.
Thank you. Alors maintenant, j'aimerais demander une question à Marie-France. Marie-France, les motifs de la majorité semblent suggérer un recalibrage subtil, je dirais, mais clair, des rôles des branches politiques et des tribunaux dans l'ordre constitutionnel canadien. Comment est-ce que cette affaire a approfondi notre compréhension de la séparation des pouvoirs?
Merci beaucoup, Vanessa. Je suis très heureuse de participer à cette discussion qui est fort enrichissante. La Cour ne fait pas référence à la séparation des pouvoirs de façon expresse dans la ville de Toronto, mais selon moi, l'arrêt nous éclaire quand même sur deux dimensions de la séparation des pouvoirs. Premièrement, la conception, et là, je rejoins un peu ce qu'Alexandra disait plus tôt, notamment en lien avec Vavilov et les municipalités, et la conception donc que les municipalités sont une entité à part entière de la branche exécutive et que donc, il y a une forte tendance dans la jurisprudence de la Cour à les traiter comme telles. Elles font très certainement partie du gouvernement au sens de l'article 32 de la Charte canadienne et dans le domaine de la responsabilité civile, à tout le moins, sans accorder aux élus municipaux l'équivalent de privilèges parlementaires, la Cour, notamment dans Prud'homme, s'est assurée que dans le cadre d'un recours en diffamation, il y ait une certaine forme d'immunité, autant en common law qu'en droit civil, lorsque l'on poursuit ces élus municipaux pour les propos qu'ils ont tenus justement devant le conseil municipal. Et pareillement, dans l'exercice lui-même du pouvoir législatif au sein des municipalités, la Cour, toujours dans le domaine de la responsabilité civile, a mis la barre très haute. Donc, on doit pratiquement prouver mauvaise foi pour pouvoir intenter avec succès la contestation en responsabilité civile d'adoption d'un règlement municipal. Et c'est vrai au Québec depuis l'affaire Furlishburg, mais c'est vrai aussi ailleurs au Canada avec l'affaire Wellbridge. Et en plus, ce qui est tout à fait surprenant, c'est que dans Ville de Nelson, qui n'est pas rendu de façon concomitante à Ville de Toronto, mais qui est quand même rendu cet automne, la Cour suprême utilise la séparation des pouvoirs pour justifier, c'est la base normative finalement, de reconnaître une immunité pour les gouvernements dans la prise de décision de politique fondamentale. Et très clairement ici, cette immunité-là pour les décisions de politique générale est applicable aux municipalités puisqu'il n'était pas ici question que la ville de Nelson ne puisse pas s'en prévaloir. C'est plutôt l'application du test de Hans qui était en cause dans la ville de Nelson. Alors, il y a toute cette forte tendance jurisprudentielle et soudain, dans la ville de Toronto, un virage presque à 180 degrés pour ramener les municipalités à un statut de simple créature de la législature provinciale. Alors ça, c'est le premier aspect pour moi de la séparation des pouvoirs dans la ville de Toronto. Et le second, qui peut-être répond un peu plus à la question, quelle est la perspective qu'a la branche judiciaire de son propre rôle, finalement, envers les autres branches? Et je pense que, très certainement, pour les dissidents, la perception de leur rôle s'inscrit dans la séparation des pouvoirs dans le sens classique à la Montesquieu du terme. Et là, je mets entre parenthèses le débat de savoir si c'est une séparation tripartite à la française et à l'américaine ou une séparation double à la britannique que nous avons au Canada. Mais très certainement, pour les dissidents, c'est le rôle de la branche judiciaire qui agit comme un contrepoids à l'action de la branche législative. Alors que, d'après moi, pour la majorité, en tout cas, le débat ne s'inscrit pas dans le fonctionnement interne de l'ordre constitutionnel et la séparation des pouvoirs à l'interne, mais semble faire quelques pas de recul et percevoir l'enjeu beaucoup plus comme la séparation entre le pouvoir judiciaire d'une part et le pouvoir constituant d'autre part. Alors, c'est une autre ligne de démarcation ici qui semble être la perspective adoptée. Et puis, pour la majorité, on peut utiliser les principes non écrits pour remplir les trous lorsque le constituant ne s'est pas exprimé, mais on ne peut pas utiliser les principes non écrits pour prendre la main du constituant, raturer les termes du texte écrit pour y substituer des termes que l'on croit plus appropriés à la lumière de l'évolution du droit constitutionnel. Alors, c'est cette démarcation-là qui semble être celle qui est prise en compte par la majorité et je me demande si ça ne nous renseigne pas aussi sur les deux approches d'interprétation constitutionnelle qu'a utilisée la Cour. Donc, l'approche d'architecture constitutionnelle qu'on a vue dans le renvoi sur le Sénat, le renvoi sur la Cour suprême, mais à laquelle on faisait déjà allusion dans le renvoi sur la sécession, lorsqu'on parlait d'architecture interne, et d'autre part, l'approche de l'arbre vivant. Et je me demande si cette approche donc de l'architecture constitutionnelle, elle n'est pas la seule approche que l'on doit utiliser lorsqu'on s'intéresse au tronc et aux branches principales de l'arbre constitutionnel canadien. C'est-à-dire que lorsque l'on s'intéresse aux institutions de la Constitution et qu'on veut les modifier, que ce soit le Sénat, que ce soit le partage de compétences entre le fédéral et le provincial, que ce soit d'ajouter une autre branche municipale qui serait une autre branche principale qui serait donc ces municipalités-là, la Cour va plutôt se demander, en ayant toujours en tête cette démarcation entre la marge de son pouvoir et celle du pouvoir constituant. Est-ce que c'est une modification constitutionnelle? Est-ce qu'on me demande ici de couper une branche principale? Est-ce qu'on me demande de transplanter le tronc, auquel cas ça appartient aux constituants? Mais par contre, si on me demande d'interpréter l'étendue des droits et libertés, là, je m'intéresse plutôt aux branches secondaires, au feuillage, qui, lui, peut croître dans les limites naturelles de l'arbre constitutionnel canadien. Alors, est-ce que cette approche de l'arbre vivant, elle est limitée aux droits et libertés pris comme le canopé de l'arbre, alors que l'architecture constitutionnelle s'intéresse plutôt au tronc? Je me demande si c'est une conclusion qu'on doit tirer là, de Ville de Toronto.
Je crois que tu viens d'articuler une nouvelle théorie d'interprétation, Marie-France, que je trouve très intéressant. Okay, I'd like to go back to Mike now. And Mike, just talk a little bit about the role that democracy plays in this case. Alors, les enjeux touchant sur la démocratie dans cette affaire étaient complexes. D'une part, les mesures contestées ont été dûment promulguées par la législature, mais d'autre part, il y avait une solide argument à faire valoir sur la prémisse que la démocratie est minée lorsque les règles du jeu sont modifiées au milieu d'une élection. Alors, je me demande quelle est la signification pour cette affaire, de cette affaire pour la démocratie en général, et puis aussi pour la démocratie en tant que principe non écrit.
Merci, Vanessa. So on the significance for democracy overall, the main point is that mid-election changes in the rules of the game, right? The rules of an election are extremely significant. I mean, if you're a candidate, you don't make the decision to run unless you know who your voters are going to be, right? Your message is crafted around the district, your fundraising strategy is crafted around the district. And so I am not personally aware of any other Canadian election where electoral districts were changed in the middle of the election. I'm happy to be corrected if that's wrong. But I believe it was a unique instance. And so for the majority, the fact that there was a new election on boundaries that themselves were not, whose constitutionality was not at issue, that was enough to answer really the charge that the harm was significant here to the candidates and the voters. In terms of the broader significance, why I worry is because have spent a long time in the literature on the law of democracy in Canada and elsewhere, trying to determine which rules allow for free and fair electoral competition and which don't, and what are the limits on partisan-minded changes to election rules, what are the limits on arbitrary changes to election rules, because the assumption being that the rules matter. And so I worry that it's not what the majority said, I'm not putting that in, but the outside of the specific terms of the case, whether this loosens some of the restraints that the court had in the Section 3 and Section 2B and Section 15 context put on what political majorities can do that may be harmful for the electoral prospects of other groups. So that's not the issue in this case, but that's the broader point that I in particular worry about, especially in a moment of democratic decline around the world where we shouldn't be complacent. On the unwritten principle, lots to say there. I would take it on the majority's own terms, okay? And so we've had this question in the air since the secession reference, whether you can invalidate a statute on the basis of an unwritten principle. The Miller cases are interesting there, as you pointed out. I read the cases differently than the majority when they summarize the case on unwritten principles, but reasonable people can disagree, right? Does the provincial judge's reference rely on an unwritten principle to strike down a legislation or not, right? So there's a bunch of examples. But the majority says unwritten principles can still be used to fill gaps and for interpretation. And so one of the questions I have is, what is a gap? And I think the view that because municipalities are talked about in the Constitution in 92.8, there is no gap. But the gap to me is not that the text says nothing, it's that how we actually practice democratic politics at the municipal level is so, and people's reasonable expectations of municipal democracy are so different from what is in the text and what is contemplated in 1867. So that doesn't necessarily determine the issue, but I think there more could have been said about whether there is a gap here rather than dismissing it because they're creatures of the provinces. On interpretation, majority says we can use the unwritten principle of democracy and interpretation. We have a series of cases on rule of law as an unwritten principle, lots on federalism because they interact with 91 and 92 and other provisions of the text. But the majority doesn't actually apply the unwritten principle and how it interprets section 2B, right? It's uncontroversial that 2B applies to municipalities, municipal elections. The question is simply, how does it apply to this unique situation? And the positive rights analysis in the Baer test swallows up the other parts of the majority judgment that suggest we should use the unwritten principle in interpretation. So to me, the unwritten principle should, at a bare minimum, guarantee procedural fairness whenever it applies. The text does not exclude fair electoral boundaries for municipalities, doesn't guarantee it, but it does not exclude it. So in that context, I think the unwritten principle would have been helpful. And I don't think it would have led to unlimited judicial discretion to impose policy preferences. I actually think in the face of abstract and general text, which is almost always the case in constitutional interpretation, the unwritten principle actually gives us some consistency and predictability and structures reasoning, if I can put it that way. So I think even on the majority's own terms, there were some questions that I would have liked to see them engage with on whether the unwritten principle could fill a gap or be used in interpretation of section 2B.
Thanks, Mike. I think this is a really important part of the decision. As you say, in some ways, you know, maybe the court reached out for this issue a little bit or dealt with it more comprehensively than it had to. But it certainly has consequences, I think, going forward. I think the reading that the majority adopts of the secession reference is probably not the standard interpretation of that case. I think you're right about some of the other cases where the court sort of hedges in its use of unwritten principles. So I think that this strong statement now that these principles can't invalidate legislation is an important one. And I'm just wondering if anyone else wants to come in on this point about the significance of the court statements about unwritten principles. Steve.
I just want to point out, particularly when you look at the minority decisions, that there's in fact there have been a few decisions in the Supreme Court of Canada pre-charter, particularly the Alberta Statutes case, Schweitz and Alberg, where the court basically did use democratic principles. Yes, they morphed it into a Section 91, 92 analysis. But when you look at those cases, the fundamental basis for those decisions was that the provinces in those cases were making decisions that basically put a damper on democracy. So in other words, in the Alberta statutes, when you regulate newspapers and democratic discourse, the court basically said, you know, obviously, you know, that's more criminal law, but the bulk of that decision is about the importance of democratic institutions, not just at election time, but throughout the entire process. Again, in Schweitzman, the court says exactly the same thing. The democracy is not just elections. Democracy is the ongoing holding of account, the ability to allow that discourse to take place. And they take that from the unwritten constitutional principles from the preamble. And all of this is pre-charter. And I find, you know, the absolute, you know, dismissal, going back to some of the points that people have been making, of the pre-charter principles of the fundamental architecture of the Constitution, and how the principles underlie that, and the majority doesn't even discuss any of how that works. And I found, you know, that a bit disconcerting, that this idea that, you know, democracy is only elections and we're only going to look at, you know, this little framing, but we have we're not going to take account of what it actually does to the institutions, the architecture itself, and which the court was prepared to do from the 1930s through the 50s, and others have indicated into the early 2000s, and that jurisprudence just wasn't even discussed, and it was sort of swept aside. So I think that's another thing that's really quite troubling, is that they're not the court didn't seem to either understand or didn't want to understand how important democracy is as an ongoing basis of how we actually govern ourselves, and they only focused on elections.
Marie-France, toi, tu avais soulevé la question de l'architecture de la Constitution et je me demande si tu penses qu'il y a des implications pour cette décision-ci pour l'architecture de la Constitution. Are we seeing, as you're sort of suggesting, like architecture becoming the dominant conception of unwritten constitutionalism, sort of in preference over these individual principles that have sort of freestanding effect?
I don't know if it's the architecture versus the principles, or if it's the written text versus the unwritten text. So I wouldn't say either way. I think the impact for the architecture, or certainly the impact of unwritten constitutional principles, is perhaps tied to the degree of development in the Supreme Court's case law. So in the secession reference, democracy on its own was not sufficient to provide an answer that was asked of the court. And in re-referendum, the Privy Council had also said, people, the electorate themselves are not a recognized constitutional actor. In Hague, referendum were not said to be binding. So perhaps there's a contradiction in the court's case law that is not allowed to give the unwritten constitutional principle of democracy its full normative force, whereas other unwritten constitutional principles like judicial independence, with very detailed specifications as to what guarantees we must have in place for there to be an independent judiciary, and it's tied to the rule of law understood as access to justice, to an independent court, might be stronger. So I wonder if there's this gradation of the force of normative unwritten constitutional principles based on their degree of development in the court's case law, in which case then Miller could perhaps help us, and any comparative study would help us to sort of enrich our understanding of unwritten constitutional principles, not a transplant per se, and without being Pierre Legrand, because I do believe that comparison is useful, and we would still need to use it as a useful tool, as a useful critical tool to sort of enrich our own understanding of it.
Alexandra, you were going to jump in here too?
Yes. So I think the point made by Steve is really critical, that the specific written provisions of the Constitution are really elaborations of underlying unwritten and organizing principles that are found in the preamble of the Constitution. And the difference between the majority and the minority is the way that this architecture is expressed. And where that becomes so meaningful in the context of municipalities is because of the long-standing and rich history of local government pre-1867, which the minority references in their opinion, but the majority dismisses. And so this kind of living tree idea, and Professor Powell mentioned this as well when he spoke about how different municipalities are now than when the Constitution was crafted over 150 years ago. So the idea that something, there's a context to how institutions develop and how principles can inform the way that courts are going to interpret constitutional provisions that have found their way into written form, but are really based on a larger architecture, a larger idea of what we want this democracy to look like. So the dismissal of municipalities in that context by the majority is very troubling. I mean, I love Mike's optimism that that even if you just look at the majority, there's still room for particular arguments to be advanced in relation to unwritten principles. And I really hope that he's right. He's right about most things. So hopefully he's right about this too. But I think in the context of municipalities, where it's really concerning is letting go of this rich history so well outlined in FCM's factum, which was just completely dismissed.
So I see that we're accumulating some great questions in the Q&A. So let me ask one more question, and then I want to move to the questions that have been posed by the studio audience. So this question relates to one piece of this, the court's analysis that we haven't talked about yet, and that is the court's freedom of expression ruling and its approach to interpreting freedom of expression. So one of the things that I found so interesting about this case is I'm working right now on a paper on the purposive approach to interpretation. And I think if you look at the approach that the majority takes, some of the language that it uses right at the beginning of its opinion, where it talks about the appropriate interpretive approach, kind of two things it does here that I think are significant, of three significant interpretive things. The first is that building on the Quebec Inc. case, they elevate the text of 2B to being sort of a primary consideration or the starting point for the principled approach. And there is a line of cases that supports that, but that is a somewhat different approach than, I think it's fair to say, the standard Big M approach. The other thing they do that I thought was fascinating is they actually invert the Big M formula. So instead of starting by saying, we take a generous and purposive, large liberal interpretation, but you don't overshoot the mark, what they say is, we start with text, you don't overshoot the mark, and then they say, but we have to admit that 2B has been interpreted very expansively. And to me, that's a really interesting and significant departure. It's subtle, but I still think it's quite important as a departure from the standard approach to interpreting charter guarantees. And again, I think, there's a couple of cases now where we've seen the court emphasizing the importance of text and not overshooting the mark. And we'll have to see whether this becomes sort of the new default approach, but I do think it's important. And then what the court, of course, does from there is to say that although 2B has been interpreted broadly, the question is different when we get to positive rights. And when we're talking about positive rights, there's a much more stringent standard that has to be made out in order for there to be a violation. And so to me, what I see happening here is the court, because I think there is a genuine issue about whether or not this is a positive rights case. And I think, the majority and the dissent have very different views about about whether this is a positive rights claim. To me, what we see here is an opening or the possibility that the courts will use this preliminary question of whether what the claimants are asking for is a positive or a negative right, to possibly funnel more cases into that positive rights space. And, I think for a guarantee that historically, the majority is quite right, has not been subject to a lot of limits. So freedom of expression is usually very easily made out. The possibility that courts might begin to view more cases as positive rights cases that triggers that more onerous standard, I think does have implications possibly for the scope of freedom of expression that the courts are willing to enforce. And I think this again raises, an issue that comes up from time to time, but which, is certainly unresolved. And that's this question of, what is the scope of the positive dimensions of the Constitution? And so, You see the dissent saying this is really not a useful framework, but it's certainly the way that the majority frames the analysis. So to me, I think this is another one of these places where, we don't really know yet where this is heading, but for a guarantee that is usually interpreted very robustly, I think the significance of the adoption of the BEAR framework is significant. Now, the Supreme Court here is following the Court of Appeal in this regard, right? So I think we also have to acknowledge where that framing comes from. The Supreme Court didn't introduce this concept for the first time by itself, right? This was the basis upon which the majority declined to give effect to the freedom of expression challenge. But to me, there is something significant happening here in terms of the scope of freedom of expression and that positive negative dimension of rights guarantees. So Mike, do you have anything you want to say on this, or anyone else on the panel?
Yeah, I'm happy to jump in. This might end up being the most enduring part of the case, in my view, and the evidence that this is not a one-off partly comes from the Frank dissent. So that's the case on the right to vote on non-resident voting. If you move out of the country for 5 years and you're a Canadian citizen, you previously lost the right to vote, court strikes that down. The dissent identifies the right to vote as a positive right. And so it's not just this case, it's also in that case. And so there is something to that, right? If you're going to have a free and fair election, someone has to count the ballots. You have to have a voting booth. And so that's a more accurate statement of things than the older view of democratic rights, which was civil and political rights are together and they're first generation negative rights. That's often the way it was written about in the literature. So I think the court is right to say there's at least a positive dimension in addition to the negative dimension to democratic rights. Now, the question is, what consequence do you draw from that? And so, the last point is it's an interesting juxtaposition that part of the majority's reasoning why we shouldn't have unwritten constitutional principles as freestanding mechanisms for striking down laws is it gives nearly unlimited judicial discretion, and the notwithstanding clause does not apply. And then there's a number of other reasons. But now under 2B, because almost any right can be characterized as having some positive aspect to it, almost any one, and there's lots of literature on that, a judge now has the opportunity to say, I'm going to apply the positive rights test, which has a higher standard. So, right, so, and they're not, so they weren't, they didn't try to say it's a different standard only, they said it's a different standard and it's harder for the claimant to meet that standard. So there is now a significant leeway for judicial discretion to be used in a variety of different ways. And so I think the positive negative is potentially a durable commitment of at least some members of the court and gives a variety of different levels of scrutiny that the courts can bring to different kinds of.
Anyone else want to jump in here? Okay, I'm going to move to the questions, the audience questions, because there are lots of great things here. Okay, good morning, Dick Moon. Would it be better to talk about underlying principles rather than unwritten principles to avoid the artificial contrast between text and principle? So, I mean, I think it's clear that some of what's happening here is this movement toward textual interpretation is related to what's happening with unwritten principles, right? It's an overall preference for or greater comfort with interpreting the textual elements of the Constitution. So would calling these principles underlying principles be better?
Je peux peut-être y aller, oui. Vanessa, et ça rejoint aussi la question de notre collègue, Charles-Maxime Panaccio, qui nous demande s'il n'y a pas un débat ici entre la majorité et la minorité quant à l'idée même de pouvoir constituant, c'est-à-dire la volonté manifestée dans la Constitution qui est rédigée, versus une Constitution de principe comme celle de l'arbre vivant. Je pense qu'effectivement, le débat est peut-être même encore plus profond, c'est-à-dire que c'est le contraste entre une approche de common lawyer, presque à la Constitution. La common law, donc les juges la découvrent, mais elle existe depuis des temps immémoriaux. Et donc, le texte écrit ici est assujetti, ou en tout cas découle de ces principes-là, et c'est très certainement l'opinion des dissidents, versus une approche peut-être un peu plus positiviste, voire même peut-être civiliste, où on préfère le texte écrit pour des raisons de stabilité, de prévisibilité, et pour qui le pouvoir constituant, c'est la manifestation du démos du peuple, alors qu'il y a un fondement démocratique aussi quand même assez fort ici. Alors, je pense qu'effectivement, on pourrait voir ce fameux débat philosophique reflété peut-être ici dans la ville de Toronto.
Steve, did you want to add something?
Yeah, my world is in fact only, is basically primarily in the area of the preamble. And I think one of the difficulties that I have encountered, or I'm a bit concerned about, is when we talk about principles, whether or not they are unwritten or whether or not we talk about underlying and what they do. The fact is there are all sorts of aspects of the Constitution that are not written. And are they necessarily principles? Are they basically provisions? For example, when you take the issue of parliamentary privilege and parliamentary sovereignty, and I mean, obviously that's not the context of this debate, but those are fundamental pieces of the architecture and fundamental pieces of the way we govern ourselves. And I think they're beyond principles. I mean, there's a whole raft of things within the Constitution, or the way we constitute ourselves, that flow from the preamble. And I think we have to be careful, not only in the question of whether or not things are written or unwritten, but what we see as principles. What do we see as, fundamental aspects? I mean, even which are sort of even beyond principles. So I mean, so there's a whole bunch of sliding in the wording in this when we talk about principles, or we talk about something being written or something that's So I think we have to be not only careful in the use of language, but I think we all have to be aware of the fact that there are all sorts of things that are part of the constitutional gun norm in Canada and from the UK and those kinds of things, and how we classify them. And they're not just gap filling. I mean, some of them are not just gap filling. They are quite fundamental. So I think the question, is the problem of how do you deal with language? But we also have to be very careful, when we start downgrading things as being unwritten or downgrading things as principles, what does that potentially mean for other aspects of the Constitution that are just not there? I mean, Mike started out this off, I think, or you did. We were talking about the Prime Minister doesn't appear anywhere. Cabinet government basically doesn't appear anywhere, but somehow it's fundamental. So I just think the language is the question is an important one, but I think we also have to be aware of what that language could do or the consequences of it.
Thank you. Okay, I'm going to riff off a question that's here for Alexandra, and it's really about, is some of the risk aversion or the hesitancy that you think we're seeing post City of Toronto, how much of that is about the uncertain legal and constitutional status of municipalities, and how much is related to the general risk aversion of governments and local governments? So I think this is, more broadly a question about how governments respond to court decisions.
Yeah, I mean, I think there's little doubt that the municipal role in Canadian federalism is far from clear. So we have, in this judgment itself, a strongly divided court. We have amongst Supreme Court of Canada jurisprudence, principles that have been outlined, ratios that have been identified that come into conflict with one another. So we've talked about Vavilov already. And then we have the practices that municipalities engage with provinces and with the federal government all the time that sees municipalities as key partners in a number of important decisions like housing and transit and otherwise, and COVID and otherwise. And I think the lack of clarity from the court on this case, which was very narrow. I mean, a case is only as strong as the facts that come before the court, right? So we're dealing with a very particular, very unusual kind of circumstance that had never been seen before. But it adds further confusion over where municipalities can cement their feet when they're making decisions and how much they have to be alive to particular personalities coming into play at the provincial level that are going to disrupt whatever kind of brokerage relationship they've come into, they've found themselves in with provincial and federal actors. And so I think municipalities are cautious, and they're cautious in part because of the lack of clarity about their role within Canadian federalism. And this case doesn't help. Is there a sharp divide between what was happening at the municipal level, before October, 2021 and now? No. I used to work at the City of Toronto, and I can attest that there was a lot of caution when they're acting in gray zones, and there always was that caution. But the jurisprudence really doesn't help provide some certainty over where they can act and where they can't. And I think that's the worrisome nature of this case, that it's divisive, it's unclear amongst the other jurisprudence, but it also leaves so many questions unanswered.
I've got a really interesting question here from our colleague Gerard Kennedy, who I'm sure a bunch of you will be interested in this question. Suppose Premier Ford had clearly promised during the campaign that he would introduce the Better Local Government Act, and he had received a clear mandate insofar as it is possible to determine that from the provincial electorate to do so in the election. How would the principle of democracy have played out in the circumstances? Anyone want to? I mean, I'm happy to maybe just start off quickly if others want to give it some time to think, because I don't think, even if the majority had not foreclosed the possibility of unwritten principles invalidating legislation, I don't think that the mere invocation of the principle of democracy leads to a clear outcome here, right? I actually think that there are kind of conflicting democratic imperatives here in a sense, right? On the one hand, you do have democratically enacted legislation that clearly has to be significant in some way. But that legislation does have the effect of undermining, I think, local democracy, particularly given the timing of those changes. And so, the question there, you almost have a conflict between these sort of two aspects of democracy. And the hard question for the court is, what do you do in that circumstance? And, I have my own thoughts about where that takes the court, but, my sense is at a minimum, you have yourself a conflict there. And to me, it's not clear that even a democratic mandate strengthens the provincial government's position in that regard. I see that, I think the role that the courts would be playing here in invalidating that legislation really would be akin to what we saw in the Miller 2 case, where, the court steps in to say, we are going to protect the political process in this basic way, that another order of government can't be allowed to interfere with an ongoing election, never mind that they technically have plenary jurisdiction. There's something about this that at a very core level interferes with democratic principles. But, I think there's still a conflict.
I would add, if I could, very briefly, I don't think it should matter in this sense. We've had numbers of conservative governments in particular. There are other examples where someone says, well, I'm going to, impose life sentences for X, or there's going to be minimum standards for Y, or whatever it happens to be, using criminal law context. It doesn't really matter what it is. The courts really don't bat an eye about the fact that, that was an electoral mandate. So the question of, what the courts do about the legislative outcome really, it may strengthen perhaps the government's hand in some way to talk about, reasonable limit, however they want to frame part of their Section 1 argument. But at the end of the day, I mean, part of the whole thing is that, you still have the legislative result, which is what focuses on, and all sorts of governments and parties have proposed all sorts of things. We'd all sit back and say, well, if you do that, it's going to be unconstitutional. I mean, just because you have a legislative mandate, I don't think that, in and of itself should look at this. I mean, there's, someone comes along, I mean, that's what autocrats are made of. I mean, I hate saying it. I mean, look at what's going on in the United States with, some of the voter suppression and those kinds of things. Well, you've got a legislative mandate. I mean, it's the impact on democracy, I mean, doesn't really or ought not to matter that much if that's part of what this is about is reining in the populist kind of stuff that a lot of charter rights and even a lot of the constitutional rights were designed to protect against. So whether or not and the last point I would make on that is that if you look at the fact that the Constitution itself limits government's capacity to deal with democratic rights. I mean, Section 33, can't be used with respect to Section 3 rights. So regardless, so even embedded in that, I mean, it wasn't even part of the discussion we had earlier, but even embedded in that, the fact that you have democratic rights themselves, there's limits on government power with respect to democratic rights themselves.
Mike, last word.
Just quickly, it would have been interesting for Section 1. The dissent is very skeptical about the pressing and substantial purpose, which very, very rarely happens at the Supreme Court level. And so the strongest articulation of the rationale would be it's a good thing for representation to have the same districts federally and provincially and municipally. That doesn't really come out until the Court of Appeal level in Ontario's argument. And so I think it would have been an interesting case for the Section 1 and pressing substantial purpose analysis had there been a longer term commitment to that rationale for the legislation from the election and then onwards.
OK, alors on doit arrêter, mais j'aimerais remercier tous les membres du panel aujourd'hui pour leur contribution. Like we said, this is certainly the beginning and not the end of the conversation about this important case. So thanks to everyone for joining us today.